दोस्तों, ये जो सिलसिला है, ये जो गठबंधन है, अब गठबंधन बहुत देख रहे हैं, ये भी गठबंधन है रोटरी क्लब ऑफ बॉम्बे वेस्ट और महासेवा महाराष्ट्र सोसाइटी वेलफेयर एसोसिएशन का, कोरोना के पहले का। जब कोरोना के पहले थे, जब हम ऐसे फिजिकल करते थे, कोरोना के टाइम में हम लोग ऑनलाइन करते थे वेबिनार, और काफ़ी सारे वीडियो हैं और उस पर ज़्यादा लोग कनेक्ट होते थे, ऐसा लगता है, क्योंकि उस वक्त टाइम भी था कोरोना में। लेकिन आज फिजिकल में भी काफ़ी लोग मौजूद हैं। इस खूबसूरत लाइन के साथ मैं आपको तालियां बजाने पर मजबूर करूंगा कि ज़िंदगी की हर सुबह कुछ शर्तें लेके आती है, और इनका स्वागत भी है। ज़िंदगी की हर सुबह कुछ शर्तें लेके आती है, शर्त मतलब सवाल, और ज़िंदगी की हर शाम कुछ तजुर्बे देके जाती है, उस शर्त का, उस सवाल का जवाब देके जाती है। तो आप आज जो हमारे महान जो स्पीकर्स हैं यहाँ पे, अलग अलग विषय पे एक्सपर्ट हैं, उनसे जो शर्त है, आपके जो सवाल आप लेके आए, निश्चित ही आप उसके जवाब लेके जाएंगे यहाँ से। जोरदार ताली हमारे सभी स्पीकर्स के लिए। सभी रोटरियंस और जितने लोग आए हैं, सभी का वार्म वेलकम, स्वागत महासेवा की तरफ से, रोटरी की तरफ से। दोस्तों, और आगे बढ़ते हुए सिलसिला शुरू करते हैं इस ज्ञान की गंगा का, जो निश्चित ही बह रही है, और आप इसको YouTube महासेवा न्यूज़ पर भी देख सकते हैं। हमारे सहकार भान वाले भी किशोर कानाडे आए हैं, उस पर भी देख सकते हैं, सहकार भान पे और महासेवा न्यूज़ दोनों पे देख सकते हैं इस वीडियो को, यदि आप मिस करेंगे तो। और इस वीडियो को ज़्यादा ज़्यादा फैलाएं, क्योंकि लोग अवेयर और एजुकेट हों। मकसद ही ये है, लोग जितना ज्ञान लेंगे समस्या नहीं होगी, समस्या, और उस वजह से लोग ऐसे एक्सपर्ट यहाँ पे आते हैं कि किस तरह से हम इसको ज़्यादा से ज़्यादा फैलाएं। ज्ञान एक अद्भुत चीज़ है। जैसे वोट लोग अब कम अवेयर हैं, आज 80% 90% यदि वोट होता है देश में, तो बहुत बड़ी तस्वीर बदलती है, और वो आप लोग सब बदल सकते हैं एक दूसरे से माउथ पब्लिसिटी करके। हमारे नॉर्थ मुंबई में पीयूष गोयल जी और भूषण पाटिल जी खड़े हुए हैं, तो मैंने भी एक सिलसिला शुरू किया। हमारे घर में 4 मेंबर हैं, मैं, पत्नी और 2 बेटियां। तो एक बेटी की उम्र है 19 साल की, तो अभी एक 15-20 दिन पहले ऑनलाइन वोट करवाया मैंने, रजिस्टर हो गया, तो वो वोट करेगी। तो हम 3 मेंबर्स हो गए, एक 16 साल की, 16 ईयर की। तो ये हम अपने घर से शुरुआत करें कि किस तरह से हम ज़्यादा से ज़्यादा वोट करें। तो 4 मेंबर्स में 3 वोटर्स हैं, तो वो वोट करेंगे। तो इस ऐसे सिलसिला अपन शुरू करें अपने घर से, अपने लोगों से, अपने नेबर से। हमने ऑनलाइन बहुत सारी वोटिंग करवाई, नेम चेंज करवाया, ताकि आपकी ताकत होगी जब भी आप वोट आप बोल सकते हैं आपके जनप्रतिनिधि को, मंत्री को, मुख्यमंत्री को, प्रधानमंत्री को। तो दोस्तों, आगे बढ़ते हुए मैं सबसे पहले आप सभी जो स्पीकर्स हैं, तो सबसे पहले हमारे रिटायर्ड जज श्री पंकज शाह जी एज ए की नोट स्पीकर हैं। तो इनके बारे में मैं थोड़ा बता दूं कि सर, इनकी क्वालिफिकेशन BA LLB प्रैक्टिस एज ए एडवोकेट 1977, मतलब लगभग 47-48 के पहले का अनुभव है इनका, और 79 तक। उसके बाद एज ए पब्लिक प्रोसिक्यूटर 1982-1984 थाने इन कल्याण, अपॉइंटेड इन 1984 एज ए जज ऑफ सिविल एंड क्रिमिनल कोर्ट इन महाराष्ट्र, पोस्टेड एज नगर एंड अदर प्लेस, वर्क एज जज एट थाने इन मुंबई फ्रॉम 1989 to 2014, मतलब 10 साल पहले ही अभी सर सेवानिवृत्त, लेकिन अभी भी काम कर रहे हैं एज ए सिविल, क्रिमिनल एंड लेबर कोर्स। तो ऐसे अवेयरनेस का सिलसिला आज सर से जानेंगे कि आर्बिट्रेशंस और मीडिएशन एक्ट है। सर, मीडिएशन एक्ट ताज़ा आया, अभी हाल ही में आया। तो ये हर चीज़ में मेरा ये मानना है कि मीडिएशन, आप मध्यस्थता होना जरूरी है। आपके जो इश्यूज़ है, कहीं ना कहीं ईगो, बहुत सारे इश्यूज़ होते हैं, तो आप मध्यस्थता करके, मीडिएशन एक्ट करके, ऑफिशियली सरकार ने मीडिएशन एक्ट बनाया। मीडिएशन और आर्बिट्रेशन में जो इश्यूज़ है वो कैसे रिजॉल्व कर सकते हैं आप, उसके बारे में मैं स्वागत करना चाहूँगा। आप सभी तालियों से जोरदार स्वागत करें। प्लीज़ वेलकम रिटायर्ड जज पंकज शाह जी, प्लीज़ सर।
So far as myself is concerned, here I am invited not as a Rotarian, but I will share with you what is the importance of the role of mediator and arbitrator in the dispute resolution. So far as dispute is concerned, everybody in the life has to invite the dispute or may be a part of it dispute. So far as cooperative society is concerned, housing cooperative societies are nowadays having 50% litigation before the court of law. That litigation can be resolved either by mediation or by resolution of the arbitrator, which is convenient to you. Here I am giving you the idea why it is so important and why it was necessary for in a recent time. It is a need of time rather to resolve your dispute amicably or by way of negotiations. Concern is what type of dispute you are to face for governing or dealing with the cooperative societies, housing societies. Mr. Prabhu is now, he is aware of these entire disputes. One other speaker, Mr. Vavikar, is come. He is also well aware of these disputes. I would like to share one example which I have experienced, or rather it is a practical matter before me. My initial days of judgeship, one matter of 1964 was before me. Those matter of 1964 was pending, that time 25 years old. That matter was being handled by one senior advocate who was having 50 years of practice. The day on which that matter came before me, his son, who was newly enrolled as advocate, was present before me. He attended that matter, and I told him, or I called him, what is the point in this matter? It is pending since last 25 years. I told him, or I suggested that there is nothing in this matter. Unnecessarily it is pending before me because nothing has been remained to be resolved in this matter by passing of time. Okay, sir. He told me that, okay, sir, I am withdrawing this matter. This happened without doing nothing. That day, that old matter has been disposed of. Next day, his father, the newly advocate who was handling that case, came before me. And in the midst of all others, I told him that your son has newly started practice and he has cooperated me to dispose of the matter, which is old one and pending for 25 years. So jokingly he said that he is a mad, he is a fool. He doesn't know that his entire education of that son has been built up on this file, on this case. So this is what happened. So that that fellow has curtailed his income. So this is happening here in these days. Moreover, nowhere, you can't say that everywhere there is dispute. 5-6 years ago, myself and one Justice Sindkar were selected for or appointed or nominated to resolve the dispute of the Lions president, Lions Club South Mumbai. There was dispute in between the office bearer who should be the next according to their mechanism, that governor or president. I don't remember exactly. So then they both came to me and said that you should select amongst the two candidates who should be the better one. It was a very difficult task to meet. So now the point is that the dispute is not in between the private dispute but also in organization. So why this is the need of time that your dispute can be resolved amicably or by sitting together. Now coming to the topic of this subject, I will not read the entirely because you all are aware of this entire thing. Arbitration and mediation, these are the recent called alternative dispute resolution scheme. Rightly says that the Arbitration Act is already there, but recently last year from October 2023, Mediation Act is also passed by the Parliament. Some of the provisions of it are yet to be enforced, but some of the provisions are enforced. The thing is more important to you that what type there are three types of schemes, three types of resources for resolution of the dispute. Why such dispute has been arising is the question. It is a tendency of every public or everyone. He is having a hidden litigating tendency. Sometimes his ego hurts, sometimes says that I am senior, sometimes says that I am superior, sometimes he says that I am contributing more. So this is the reasons or causes for arising of dispute. My experience of as a judge for near about 35 years, we were forced to make some time to resolve the dispute by amicable settlement. Major dispute is arising between the commercial dispute, then matrimonial disputes, then between the brothers and sisters. All these disputes can be resolved very well amicably. Why it is a question before you, layman, why the litigation is prolonged for years together? Is it correct that the judges are the cause for the litigation, prolonging of the litigation? Would it be correct that advocates are causes for the prolonging the litigation? Would it be correct to say that the you peoples are also the cause for the prolonging of litigation? No. The litigation take its own course. You must aware that every litigation can be resolved within 1 day, within a minute, or within a year also. Or it also takes more than 10 years also. So don't blame to anyone that my dispute is, my case is, my litigation is prolonged for long together because of certain reason. This is what the necessary for this need of time, or this is for the necessary that when you are litigating before the court of law, you must aware that what is the reality of my litigation. What is the cause of my litigation? Would it be proper for me that I should resolve it amicably, whether I should sit together, whether I can negotiate? If you understood all these things properly, there would not be any litigation. The court of law in the India or on the land of our India is necessary. It is the mechanism provided by the Constitution of India. You know that the judiciary is the third pillar of our constitution or democratic pattern. But why this third pillar is burdened more and more by litigation? This is the question before everybody, and this can be resolved if you understood the very cause of your litigation, your dispute. Coming to the point, why the need of arbitration? Arbitration is a parallel to the court. You are choosing the judge of your arbitrator as arbitrator by your own. Sometimes the court are making the references to the arbitration tribunal, either the sole tribunal or a multiple tribunal. That tribunal is having a reference of dispute. What the dispute can be resolved. Commercial dispute is invariably by virtue of an agreement between the parties. It refers to the arbitrator. The very objective of the arbitration is that it should be resolved within time bound. You are entering into agreement with the other party, or there will be a mutual agreement that in case of, or in the event of any dispute about the contract, about the commercial dispute or anything relating to the product, relating to the payment, relating to the quality and control, the party enters into the agreement that dispute can be resolved by arbitrator. So arbitrator is a person, or sometimes court is required to choose. Sometimes there is no consensus between the parties who should be the arbitrator. Then court intervenes, and that they are appointing the expert of the field, sometimes retired judges, sometimes any social worker, to resolve the dispute by way of arbitration. This is the very scheme of the arbitration. You are all aware about this scheme, because the arbitration is one sort of such a method, or it is a method whereby you curtailing your entire litigation or your tendency of litigation at one stroke by entering into arbitration agreement and deciding the arbitration your dispute by arbitration. There is appeal also. There is also a recourse for filing of appeal or challenging that award of the arbitration, if provided that arbitrator has acted biasly or there is perversity in his finding, there is no recording of revision, why he is passing this award. So that is a different thing. Here before you, I would suggest what type of method you choose is up to you. So far as mediation is concerned, mediation is one sort of such a scheme which is introduced that mediators are trained. They are having background of good or rather intellectual experience of the field concerned they were served or they were rendering their services. So mediation, you can be a mediator, anyone can be a mediator, you can enter into an agreement of mediation. So far as cooperative society is concerned, housing society is concerned, the managing committee has to pass certain resolution relating to the affairs governing of the society. Obviously it is but natural that some members were not happy with that decision. Some members say that they are perturbed by the decision. Some of the thinking that only it is for the purpose of or for the beneficial of few members only, for the purpose of the few members of the society only. Then in that connection, the dispute goes to the court, cooperative court. Cooperative court takes its own time like the other civil court. The very nature of the dispute is, if you understood, then it can be resolved within yourself by appointing anyone to be a mediator. Who can be a mediator is not more important nowadays. But how it could be resolved is more important. So far as mediation is concerned, if you are having a litigation before the court of law, of the pending of litigation, or it is pre-trial mediation, pre-trial dispute, then the mediator can come to your help for resolving your dispute. High Court and the Legal Service Authority of India has introduced this scheme, pre-litigation mediation. It is made compulsory for certain acts like Consumer Protection Act, then matrimonial disputes, then Cooperative Societies Act, then so far as Company Act, Commercial Court Acts. For these enactments, the pre-trial mediation is made compulsory. In this respect, I would like to suggest you that whatever your pendency of litigation is, whatever your litigation before the court, you both parties or anyone can request to the court that it should be referred to the mediator. Mediator are having a skill, such skill he utilizes for bringing the parties together to certain level of resolution. He is not forcing. He is inviting you that do like this, enter into this, negotiate in this fashion, in this manner. So this sort of mechanism which is made available to you is maximum you utilize in your day-to-day life, in your pending matters, in your society, or for any other commercial area or grey area which are having such dispute arises. It would be better that you should take the utilization of this scheme. So far as choosing of the mediator is concerned, who should be a mediator? Mediator is the most important person, like arbitrator. If there is arbitration agreement, then the arbitrator has to work according to the norms laid down, or it is a parallel code. In fact, you are getting the same opportunity which you get before the court of law. But so far mediator is concerned, the person being a mediator is coming from the society or coming from the area of the field wherein he has gained such an experience that experience will be counted for resolution of the dispute. Sometimes parties are not aware, though it was a forced litigation of him, but he is not aware what are the rights, what are the loopholes of the law, and what is the position of the law regarding to his matter. Yesterday only one Supreme Court before the Supreme Court one matter. In that matter, the party forgot to deposit only rupees 14, which was the decreed amount to be payable to the other side. He forgot to deposit that 14. So when the order of the court is to obtain that the entire amount which has been deposited payable to the other side, then that time other side has raised objection that he has deposited less, rupees only 14. Rupees 14 he has deposited, the matter went to the Supreme Court. He was claiming that he didn't acted as per the order of the court, as per the decree of the court, therefore he is not entitled to get the fruits of the decree. The matter went to the Supreme Court yesterday. The court has directed to that party who has to get the fruits of the decree, that you are not aware of your right, you are not aware of your what to do, how much you have to deposit, and now after the lapse of 14-20 years, you are coming before the court saying that I am ready to deposit that deficit or make the good. Court say nothing doing. You drag that person other side to the Supreme Court. So Supreme Court has awarded rupees 1 lakh as a compensation to that other party. This is the position, that if you are not aware of your what you are required to do, then you may lose the case, even though you have got the fruits, you have got the decree. The point is only that when you are entering into litigation, atmosphere is to be taken by you, that whether my right has been hampered, whether I can be in a compromised position, where I can resolve it at this juncture or at this today, which would give me more fruits than today. If this thinking is adopted, there will be obviously, you will be in a better position, you will get more satisfaction, and you would not lose your temper, you would not lose your interest in the matter itself. Coming to the other point of this cooperative society is concerned, why the cooperative societies are formed, the history behind it. Cooperative societies are because of the land shortage, then more and more crowded cities. So the multiple stories building has been come up, and there the affairs of that building or that society is to be, that complex is to be governed in a safely manner or smoothly manner. Therefore, this Cooperative Society Act, Cooperative Housing Society is the separate chapter is provided in the Cooperative Societies Act. Some members are not paying maintenance, some are paying, some are not contributing for the common amenities, some are developing the area of the flat or the compartment or the apartment in such a manner that it affects the very varied foundation of the building. In that sense, if even though you are covering yourself that I have a right to do what is my enjoyment, it doesn't mean that you can hamper the interest of the others also. So these disputes, this type of disputes are invariably approaching to the court of law. It's not only for the cooperative court, but it takes the matter to the criminal court also, civil court also. Sometimes the matter goes to such extent that there is fight in between the members. There is some criminal actions, criminal activities into the background of that dispute. So it is better that first, if you understood, and for that the dispute can be resolved in a different manner, so you must adopt the theory of mediation, and that is important in your interest. I am not taking you the time. I am not taking you to such what are the provisions or what are the details in the cooperative society relating to the dispute. But in general, if you understood that my dispute can be resolved at my level itself without approaching to the court of law, so it is better to adopt the course of mediator. To adopt the course of mediator means you choose the mediator who can be such a person who can resolve your dispute, on whom you can believe or you can keep a trust. So at this juncture, without taking more time, very briefly I have explained before you what is the role of dispute resolution, what is the importance of the dispute resolution of the dispute by way of alternative dispute resolution. It is my sincere request that at your level you took the opportunity of this available recourse and get it resolved. Thanks.